the investigation is over. The federal investigation is over because the man in charge of the federal investigation says she ran him over. In an exclusive interview with the New York Times yesterday, Donald Trump said she ran him over. She didn't try to run him over. She ran him over. That is a lie. But that is the conclusion of the man in charge of the federal investigation of a federal ICE agent shooting and killing an unarmed 37-year-old mother who was committing no crime. To prove his point, Donald Trump summoned a staff member with a laptop to show a video of the shooting. It's one of the videos that we've all seen. And of course, it shows that she did not run him over. Donald Trump's FBI has decided to break with standard practice in this case and conduct an investigation without including state and local law enforcement in their federal investigation. That means there will be no real federal investigation. Donald Trump's Attorney General and Donald Trump's FBI Director know that they and everyone working for them must do everything they can to support Donald Trump's lie she ran him over. The way to do that is to not interview witnesses and not reveal any of the investigative material that they collect in their investigation. They will not interview the ICE agent who pulled the trigger because they don't want him saying anything that could cause problems for him in future litigation or future investigations, which could include civil litigation. This was homicide. Not all homicide is criminal. The term homicide simply means that a person was killed by another person. In any homicide investigation, the two most important places to begin are with the weapon and the body. The FBI, run by Donald Trump, has the weapon. They have the gun. But that's all they have. According to the Minneapolis Mayor's Office, the Hennepin County Medical Examiner has the body. And the body tells a story that no other evidence can. That means the Hennepin County Medical Examiner also has the bullets, or the single bullet that entered the body and killed Renee Good. Using the trajectory of bullets through a body, a medical examiner can tell us which bullet was the deadly bullet. A medical examiner can tell us which way she was facing or turning when she was hit by that bullet. Was it the first bullet, the second bullet, the third shot fired? In this case, investigators freeze framing the video can determine, based on the medical examiner's findings, whether the first shot that appeared to go through the windshield was a miss. And matching this freeze frame to the trajectory of the bullets and the bullet in the body, investigators could determine which of those bullets fired from the position beside the car was the deadly shot. Was that one? You see that hand extended, that single, one hand on the gun extended to the car, which is beyond the shooter now. He's no longer just beside that window. That car is beyond him. He's still shooting at that woman, posing absolutely no threat to him at that time. With that gun extended, aimed to that driver, there is no threat to the person firing that gun. Was that shot the fatal shot? Medical examiner might be able to determine that. That shot was fired from beside the car. The car was moving away from all of the ICE agents at that time, posing a threat to absolutely no one. The agent firing that shot from beside the car was in absolutely no danger when he was standing beside the car that had passed him already at that point. Still shot. Of course, in a proper investigation, the ballistics evidence from the bullet itself would be used to determine the exact sequence of the shot. The ballistics evidence from the gun matters. That tells us the sequence of shots. But the FBI has the gun, and the FBI controls the ballistics evidence that is in their possession. When the shots are fired into cars, most of the time they miss their target in the cars. Most police bullets fired at or into cars miss. And the bullets that miss are found somewhere in the car. We do not know tonight if the FBI is in possession of bullets found in the car. And it may be that no bullets were actually lodged in the body. It is possible that the fatal bullet passed through the body, but it is very likely that the medical examiner is in possession of at least one bullet. So the FBI cannot possibly conduct a real investigation without the medical examiner's cooperation. And most importantly, Donald Trump's federal government cannot control the findings of the medical examiner. Donald Trump can control everything else, but not the autopsy report. Donald Trump will do what he has to do, and if that involves suppressing evidence, then everyone working for Donald Trump in the FBI and the Justice Department is obviously more than eager to do that, as they have demonstrated by Donald Trump's former criminal defense lawyer, who is now the Deputy Attorney General, going to Florida to interview Donald Trump's old friend, Ghislaine Maxwell, who was convicted of sex trafficking with Donald Trump's other old friend, the now dead Jeffrey Epstein. That was a case study in the suppression of evidence about Jeffrey Epstein and Ghislaine Maxwell by Donald Trump's personal criminal defense lawyer, who now serves as his Deputy Attorney General and will no doubt be functioning in effect as the personal criminal defense lawyer of the ICE agent who killed Renee Good. J.D. Vance tried to supercharge his presidential campaign today by taking to the White House press briefing room to call Renee Good, quote, a deranged leftist, end quote. How does he know that? He offered absolutely no suggestion about how he knows anything about her. In fact, he knows nothing about her. He also went there to declare Donald Trump's deadly force of ICE agents are licensed to kill. That's what J.D. Vance in effect said, and he extended that license in effect to every federal agent working for Donald Trump. J.D. Vance, a graduate of Yale Law School, disgraced that institution once again by telling this lie about the agent who killed Renee Good. Quote, that guy is protected by absolute immunity. The unprecedented thing is the idea that a local official can actually prosecute a federal official with absolute immunity. That is not unprecedented, as Yale Law School could have taught him. On this program last night, you heard former FBI agent Ron D'Amico talk about a local prosecution of an FBI agent, a case that he was very familiar with. And in that case, the FBI agent was actually found not guilty in that local prosecution. J.D. Vance was more careful than Donald Trump on only one point. Instead of telling the provable lie, she ran him over, J.D. Vance said, quote, she was trying to ram this guy with her car. And J.D. Vance was right to say that some of what happened on that street is something that we could debate. J.D. Vance said, look, if people want to say that we should have a legitimate debate about, what was she really doing, right? Was she panicking when she drove into this officer, or was she actually trying to ram him? That's a reasonable conversation. And the place for that reasonable conversation is a courtroom or a grand jury room. If this case were to make it to court as a criminal case or as a civil rights wrongful death lawsuit, then the defense would obviously be that she tried to run the officer down with her car, tried to. And a jury could watch the video and listen to other eyewitnesses, and in a criminal case, make a decision beyond a reasonable doubt, or in a civil case, make a decision based simply on what is more likely. The standard of proof in a civil case is lower than in a criminal case. So J.D. Vance says that it is legitimate to debate exactly what was happening on that street. He supports Donald Trump in refusing to have a real investigation of what happened on that street. And he immediately concludes that there really is nothing to debate. J.D. Vance said, quote, the reason this woman is dead is because she tried to ram somebody with her car, and that guy acted in self-defense. So there's the Vice President of the United States with his case closed declaration about exactly the kind of case the federal government would investigate carefully if anyone other than Donald Trump were president of the United States. After hearing the vice president's final judgment on the case, one reporter asked J.D. Vance if he had access to any information at all about the case that was not already public. And he didn't. He doesn't know anything that we don't know. So J.D. Vance is working with exactly the same evidence that all the rest of us have. And in a second point of disgrace for Yale Law School, J.D. Vance suggested that something that happened 6 months ago in a different town was a reason to shoot and kill Renee Good. J.D. Vance said, quote, that very ICE officer nearly had his life ended, dragged by a car 6 months ago, 33 stitches in his leg. So you think maybe he's a little bit sensitive about somebody ramming him with an automobile? Yes, J.D. Vance, I do think he's a little bit sensitive about that. That's a very good point, Mr. Vice President. And that is a reason why that ICE agent should not be on the street after an incident like that, because we cannot trust the judgment of angry men with guns who bring previous experiences to their next law enforcement encounter and decide to shoot and kill in exactly the same situation where this same agent 6 months ago decided not to shoot and kill. And the person this agent decided not to shoot and kill 6 months ago is now in prison, awaiting sentencing for interfering with a federal agent. Following the Minnesota Star Tribune, MS Now identified the ICE officer who fatally shot Renee Good as Jonathan Ross. The New York Times has confirmed that identification in an affidavit filed in the United States of America versus Roberto Carlos Munoz on June 17th of last year, included a description by an FBI agent who investigated the case of what happened to Jonathan Ross in that incident. The affidavit says that he approached Munoz's car knowing that Munoz had previously been arrested for sexual abuse, and that Munoz was a citizen of Guatemala. And so they went to arrest him at his residence in Bloomington, Minnesota. They found Munoz in his car. The affidavit says that Jonathan Ross, quote, approached the driver's side window of Munoz's vehicle and commanded Munoz to place the vehicle in park. The ARO officer unholstered his taser with his left hand and pointed it at Munoz's chest. The ERO officer's commands were made in both English and Spanish. While the ERO officer's right arm was inside the vehicle, Munoz put the vehicle in drive. The ERO officer's right arm was caught in the vehicle. As Munoz fled, the ERO officer was dragged along with the vehicle as Munoz drove away. Jonathan Ross was hanging in that window, being dragged by it being stuck in the window of that car for about 100 yards before he was able to get his arm out of there and fall to the street. Roberto Munoz was arrested about a mile from the scene. The affidavit shows photographs of Officer Ross's injuries, including a photograph of 20 stitches required in his right arm, along with 13 stitches in his left hand. So that's how Jonathan Ross approached a car 6 months ago. And J.D. Vance thinks because of that, quote, maybe he's a little bit sensitive about somebody ramming him with an automobile. In other words, J.D. Vance thinks another car Jonathan Ross approaches, which is not being driven by anyone who has ever been charged with a crime, a car that's being driven by an American citizen, a car that is being driven by a mother of three, when that agent walks up to that car, that person might just get killed because of what someone else did 6 months ago. And that's true. That is the human truth of police work. That is the human reality of police work. Law enforcement is populated by human beings who have resentment, human beings who have angers. But unlike the rest of us, they are not legally allowed to indulge their resentments and their angers in the line of duty with guns in their hands. And that's exactly why, after what happened to Jonathan Ross 6 months ago, he should not have been on the streets looking for trouble or causing trouble. There's plenty of work to do in the federal government, indoors, at ICE headquarters, in the ICE office. That's where you keep him after an experience like that 6 months ago. 4 years from now, with the new Attorney General appointed by a Democratic president and a new U.S. Attorney in Minneapolis appointed by a Democratic president, Jonathan Ross could be subject to an honest federal investigation of what happened on that street. And so, if you think Donald Trump did a lot of pardoning on his first day in office, on his last day in office, he could be pardoning every single member of Trump's deadly force. Leading off our discussion tonight is Professor Laurence Tribe, who has taught constitutional law at Harvard Law School 4 or 5 decades. Professor Tribe, very eager to get your view of the intersection of federal state law, federal state jurisdictions here.
Before saying anything more, I want to say how sad I am at the terrible fate that Renee Good suffered for simply being where she had a right to be and exercising her First Amendment rights. She had a First Amendment right to be observing and making recordings of what ICE was doing, and apparently to listen to the president, to listen to the vice president and Kristi Noem. When you are objecting to ICE because of its violence and its cruelty and documenting what they're doing, you are obstructing them and giving them license to kill. That's not our law. Only 7 circuits of the 11 have considered the question of whether the First Amendment includes a right to make video recordings of what federal officials are doing. And all 7 have said, yes, there is such a right. Now, the question is, when someone is exercising that right and an officer, a federal officer, comes up and shoots her dead, what law applies? To listen to J.D. Vance, there's some magic that happens. The officer is kind of surrounded by a bubble of absolute immunity, something like what President Trump was given by the Supreme Court. But there is no such bubble. There is a qualified immunity, but the state laws of murder, the state laws of assault, and other generally applicable state laws continue to apply, even to a federal officer. The principle goes back to 1890 at the very least, and there was an extraordinary exchange in which Justice Stephen Field, a Supreme Court justice, was encountered at a railway station in California by a former California Supreme Court justice, and the California justice decided to assault Stephen Field. There had been a long resentment between them, and this guy decides, because he is deputized by the Attorney General to protect Stephen Field, as a federal official, he shoots the assailant in order to defend the justice. California proceeded to put the guy on trial for murder, and the U.S. Supreme Court said it's a close case, but in this case, he was exercising his federal role and going no further than he needed to protect the Supreme Court justice, so he was immune. But that conclusion followed a long analysis. It wasn't simply announced from the press room by some president or vice president. The law, ever since then, for about 140 years, has been very clear that if you are engaged in a federal job, including a federal job of investigating, a federal job of going after immigrants the way ICE does, the only immunity you have if you violate a state law against doing grave bodily harm is the immunity that you get when you are exercising your job and going no further than reasonably necessary. And all of us who watched those very sad videos from every angle could say that it didn't look like it was reasonably necessary for Jonathan Ross to kill this woman. On the contrary, she wasn't doing any of the things that the president and the vice president and Kristi Noem lied and accused her of doing. So it looks like a reasonable investigation would come to the conclusion that there was no immunity. But to avoid that investigation, these federal officials, the president, the vice president, the secretary of the Homeland Security Department, all of them, having reached a conclusion, don't really want a meaningful investigation. So they want to make it harder for the state to prosecute the case. For example, they are not likely, as you said, to turn over the gun, without which, even though the coroner may find some of the bullets, without the gun, it's going to be harder. The fact, however, is that if the state does prosecute, what's likely to happen is that the federal officials are likely to try to remove the case to federal court. And under a federal law, 28 U.S. Code Section 1442, under that law, they might be likely to succeed in getting it moved. But even if the forum is changed, the prosecutors would still be the state prosecutors from Hennepin County. Now, what is gained by tying their hands, by withholding evidence from them? Nothing. It's simply an obstruction of justice. And it may well be that a federal court would put pressure through a writ of mandamus, put pressure on the Federal Bureau of Investigation to share some of its evidence with the state. But as you point out, in any case, unless the current president on his way out grants a pardon to this officer who, perhaps because of his PTSD, killed an innocent woman, if the president on his way out doesn't grant that pardon, the next attorney general and the next Justice Department will hopefully be able to prosecute. So the intersection of state and federal power here is intricate. But one thing is clear, it is nothing like what the vice president, who should have known better, I think Yale Law School teaches better, nothing like what the vice president claimed. Among his misrepresentations, apart from his misrepresenting the facts, was that he completely misrepresented the law. And we are witnessing a lawless administration terrorizing communities, endangering lives in the name of making us safer, and then trying to cover up what really happened. It's disgraceful, and it should make us all sad about where we find ourselves.
Professor Laurence Tribe, always an honor to have you join us. We just learned a lot. Thank you very much for starting off our coverage tonight.
Thank you.
And coming up, we'll show you a New York Times assembly of multiple videos of the shooting, including the video that Donald Trump is relying on. That's next. The New York Times has assembled multiple available videos of the shooting and provides this analysis.
This is the agent who shoots the driver. He walks around the car filming and disappears from view. Other agents pull up and order the driver to exit her vehicle. One of them grabs at the door handle and reaches inside. The SUV reverses, then turns right, apparently attempting to leave. At the same time, the agent filming crosses toward the left of the vehicle and grabs his gun. He opens fire on the motorist and continues shooting as she drives past. The moment the agent fires, he is standing here, to the left of the SUV, and the wheels are pointing to the right, away from the agent. This appears to conflict with allegations that the SUV was ramming or about to ram the officer. President Trump and others said the federal agent was hit by the SUV, often pointing to another video filmed from a different angle. And it's true that at this moment in this grainy low-resolution footage, it does look like the agent is being struck by the SUV. But when we synchronize it with the first clip, we can see the agent is not being run over. In fact, his feet are positioned away from the SUV.
Joining us now is Kirk Burkhalter, criminal law professor at New York Law School, where he is the director of the 21st Century Policing Project. He's a former NYPD detective. Thank you very much for joining us tonight. There are two tactical points here that I'd like you to take a look at. One is we see in the New York Times video the shooter, when this begins, the only thing he's doing with his hands is he has his phone up, using it as apparently a video camera. So when the shooting occurs, he apparently has the camera in one hand and the gun in the other, one-handed shooting with the gun in just his right hand.
Yes. In my experience, if you are in a situation where your firearm has to be out or you're contemplating using your firearm, you're going to use both hands. It's more important to hold that firearm properly, maintain control over it, get an accurate fix on your target, rather than to also use your cell phone in any manner. So that is quite odd, to say the least.
Yeah, and what does it do to the necessary judgment and focus when you've got, your left hand is doing one thing, which requires one section of the brain, that video, and then your right hand is doing the most important thing it can do?
Well, yeah, I think you hit the nail on the head. The most important thing you can do. The use of a firearm in some type of combat situation is probably one of the most serious things any person is ever going to have to do in their life. And in a perfect world, all your attention would be focused on that firearm. I don't see in any way that the phone would provide any defensive capabilities whatsoever. But there's also a larger point here that's reflected in the conversation you have with your last guest and here. And it's often lost in these situations, and that is the sanctity of life. And we can kind of look at the nuances as to the way the wheels were turned and whether necessary force was used. But at the end of the day, do the actions represent, are they reflective of someone who respects the sanctity of life? And that's mission number one for law enforcement. And as a matter of fact, when we think about law enforcement, that's what we think of. That's what we are here to protect. So all of these actions, one hand on the firearm, another hand on the cell phone, firing multiple shots while standing next to the car, certainly darn near shooting a fleeing felon. Do these actions represent the sanctity of life? After all, that's the spirit of the law, and that's what the law is meant to protect. So that's also the larger conversation here. All these points feed into that, or funnel rather, into that one point.
The other tactical point of interest here is that only one agent on that scene fires a gun. Every other agent on the scene makes the judgment that that's not necessary. And the one who's so important here is the first agent to actually touch the car, who's reaching in, who's doing what the FBI report indicates that Agent Ross was doing 6 months ago, reaching his arm into the car. He's the closest to the driver. That agent never even considers taking out his gun, and he's the one who's absolutely closest to the driver during most of that action.
Well, Lawrence, it's a very dangerous thing to fire a gun at a vehicle where someone is driving, because we saw exactly what the result is. When that driver is incapacitated, that car is turned into a dangerous weapon. It just keeps going, and it's amazing that no one else was injured or killed. In most jurisdictions, well, I won't say most jurisdictions, but in many jurisdictions, there are prohibitions against even firing a weapon at a car, even if that car is being used as a weapon, unless there is another weapon. In particular, New York has a rule like that. So it's very dangerous to begin with. And most of the time, you'll see someone trying to reach into car, do something else, or simply step out of the way. And without the Monday morning quarterbacking, you can look at this video and make a determination for yourself whether someone could have stepped out of the way. Whatever this person was wanted for, It certainly wasn't a felony. It wasn't a capital offense. When the victim, if she flees the scene, all they have to do is go to her home and arrest her. So there are many options to combat the use of this vehicle in whatever manner it was being used here. But as we pointed out earlier, has been pointed out earlier, it appears that the wheels were turned and the victim was simply trying to drive off.
Law Professor Kirk Burkhalter, former NYPD detective, thank you very much for joining us tonight.
You're quite welcome, Lawrence.
And coming up, Congressman Ro Khanna is asking a judge now to force Donald Trump's Justice Department to release the Epstein files as required by the law Ro Khanna wrote and was passed by the House and the Senate with only one vote against it. That's next. As first reported by MS Now today, Democratic Congressman Ro Khanna and Republican Congressman Thomas Massie, the co-authors of the Epstein Files Transparency Act, have formally asked a federal judge to appoint a special master and independent monitor to compel the Trump Justice Department to release all of the Epstein files. The congressman, writing in a letter to U.S. District Judge Paul Engelmeyer, said the department failed to meet the Act's requirements in multiple respects, including missing the statutory deadline asserting common law privileges that the Act does not permit, and applying extensive redactions that appear inconsistent with the Act's expressed prohibition on withholding or redacting records to protect politically exposed persons. Put simply, the Department of Justice cannot be trusted with making mandatory disclosures under the Act. Congressman Khanna was also part of a group of Democrats in the House Oversight Committee who wrote to Republican Chairman James Comer today, demanding that he compel Attorney General Pam Bondi to testify at a hearing on the Epstein files release. And joining us now is Democratic Congressman Ro Khanna of California. Thank you very much for joining us tonight, Congressman Khanna. So the special master request by a judge, procedurally, this is a kind of a request that's made all the time in various forms of litigation, and judges usually make it on the decision on the basis of, is there any other way for this to be handled fairly? And if not, we may need a special master. So this could be the key that unlocks this lock.
You're absolutely right, Lawrence. Judge Engelmeyer has been very thoughtful and deliberate about his rulings. He has cited the Epstein Transparency Act, saying that DOJ has an obligation to release the documents. And Pam Bondi has been communicating with the judge, saying we still have 2 million documents to release. 2/3 of the attorneys in the Southern District of New York are working on this right now. And so what we're saying is, Judge Engelmeyer, appoint a special master so that we know that we're getting the information that the law requires. The DOJ has not been providing that. They have been engaged in excessive redactions. Why don't you ensure that the law is being followed?
And a special master like that really reports to the judge. The judge can check in on the special master. How many documents now? How's the progress going? They schedule regular meetings in court with those kinds of special masters, don't they?
Absolutely. And it's a common practice when you have millions of documents involved, when you literally have 2/3 of our lawyers in the Southern District of New York, one of the most important U.S. Attorney's Office working on this, when the country is looking at what should happen. What this says is the special master will look at the law, the plain reading of the law, and will determine what should come out and what should be protected. Frankly, the DOJ should welcome this, have an independent person. We're not saying Massie or I should do it. We're not saying the survivor's lawyer should do it. We're just saying have a judge appoint an independent person to interpret the statute and have a release of these documents.
And this is such an interesting angle on this, because normally between the executive branch and the legislative branch, when there's an issue of this sort, it gets worked out, and it gets worked out in good faith. And the executive branch might say, well, look, this is taking us longer than we thought. They come over, they explain why, they show you why. You go, okay. But since this is so contentious and they are obviously so untrustworthy, this is what has forced you to court.
It's unfortunate. We tried to extend the benefit of the doubt. Thomas Massie and I requested meetings with the Department of Justice. We requested with Bradley Edwards, who was the lawyer for the survivors, saying at least consult the survivors. As you remember, They didn't even call the survivors or the survivors' lawyers on the first release. We didn't criticize them until that first release. But now, weeks after the deadline, they have not explained the redactions. By their own admission, they have millions of documents. And our interest is not to score points against Pam Bondi. Our interest is the survivors. We just want these documents released, especially the 302 statements where the survivors name the other rich and powerful men who were involved in the rapes and in the abuse. And I have extraordinary confidence in Judge Engelmayer. His decisions have been very thoughtful, and I believe he would appoint a person of integrity to oversee this process.
And that would be a huge breakthrough. Congressman Ro Khanna, thank you very much for joining us tonight.
Thank you.
And coming up this afternoon, a group of House Republicans joined the Democrats to defy Donald Trump and pass a Democratic bill to restore Affordable Care Act subsidies. Congressman Brendan Boyle, who helped force that vote in the House, joins us next. Today in the United States Senate, 5 Republican senators rebelled against Donald Trump and voted with the Democrats to advance a war powers resolution that would require congressional approval before Donald Trump can expand any military action in Venezuela. And Donald Trump responded the only way he knows how. On social media, Donald Trump said Republicans should be ashamed of the senators that just voted with Democrats and attempted to take away our power to fight and defend the United States of America. Susan Collins, Lisa Murkowski, Rand Paul, Josh Hawley, and Todd Young should never be elected to office again. That is something no other president ever says about members of his own party who cast a vote that the president doesn't like. That's a Trump thing. Republican Senator Rand Paul of Kentucky said this.
If a Congress actually had gumption or a Congress actually had wherewithal, a Congress could check a president. That's the way our founding fathers intended it to be.
And in the House of Representatives, with Speaker Mike Johnson's majority shrinking, Donald Trump faced another Republican rebellion. 17 Republicans joined every Democrat in a 230 to 196 vote to restore Affordable Care Act health care tax credits for 3 years. That is the Democratic proposal all along. Congressman Brendan Boyle, one of the Democrats who forced that vote to happen through a discharge petition. And joining us now is Democratic Congressman Brendan Boyle of Pennsylvania. He's the ranking member of the Budget Committee, member of the House Ways and Means Committee. Congressman Boyle, this was just impossible territory a short time ago, but the rebellion apparently is underway with some Republicans in some situations.
You know, today was a good day. The fact that every single House Democrat and a surprisingly high number of House Republicans actually joined together to do the right thing and pass a clean 3-year extension of the Obamacare credit. So the fact that we were able to pass this despite a Republican majority who opposed it and despite a Speaker of the House who opposed it, now it goes to the Senate where Republican senators will be under pressure. Are they going to listen to the overwhelming majority of the American people who want these Obamacare credits extended, or are they going to continue to follow what Donald Trump orders them to do?
As we go forward, what else can we expect with this now that there is a possibility of rebellion in the House in numbers that can actually pass bills?
Well, it's pretty remarkable when you consider the fact that until the last couple months, only 2 discharge petitions had ever succeeded this century. And now we have had 3 succeed just in the last 6 weeks. So it shows you what a weak position the Republican Speaker is in, and then also President Trump is in. As you see Donald Trump's numbers continue to fall, I think we're only going to see more rebellions on more votes from Republicans who are starting to get very nervous about that midterm election, which is literally only 10, 11 months away.
And let's remember what this vote was about for the audience. The Congressional Budget Office, the experts on these estimates, say that with this vote today, if this becomes law, 100,000 people this year will be able to obtain health insurance that they wouldn't have, and 3 million in 2027, 4 million in 2028. So this is a massive opportunity for millions of people out there.
Yeah, and let's not forget why we're here, Lawrence, in the first place. The original sin is the Republican tax bill that they passed this summer, which provides over $5 trillion worth of tax cuts for the super rich, paid for by the largest cuts to health care in American history. The Congressional Budget Office estimates about 15 million Americans will lose their health care as a result of that bill unless we take action now to mitigate at least some of those cuts.
Pennsylvania Congressman Brendan Boyle, thank you very much for joining us tonight.
Thank you.
Tonight's last word is next. Former constitutional law professor Jamie Raskin, who first studied constitutional law as a student of Harvard law professor Lawrence Tribe, said this today in a House Judiciary Committee hearing.
Now, Ms. Good, who's a 37-year-old mom of a 6-year-old boy, now orphaned by ICE, posed no threat to anybody. At least, as far as we can tell, there's no suggestion that she posed a reasonable threat to anybody. That's the legal question. Now, I think our committee should launch an investigation into this. This would be a worthwhile subject for us to get into at this point. But the idea that simply because she disobeyed an order that she can be shot in the face at point blank is wrong. That's not the law in the United States of America.
Congressman Jamie Raskin gets tonight's last word.